We are having a few of us sitting together in the conference room and the others dialing in. So while we have a bit of a live discussion going on here in the conference room, hopefully later today, at the same time, we are having you dialing in. We use Zoom today. I have to say I'm not the most experienced with Zoom. I'm more of a Teams person, but we have Zoom today because we wanted to hear the opinion of the audience, of you out there. How did this start? This started as you registered, you saw CLPD. Who is a non-lawyer? You were wondering what that is. CLPD is continuous training, what lawyers need to do. So this started as a presentation for our own lawyers to update on the new law. And then we thought, hold on, we have so many discussions with our friends from clubs, from insurance companies, ship owners. Why not opening this up and allowing others to participate as well? I'm not saying listening, I'm saying participating, because it would be nice if we have an active discussion going on here. Why you will see in a little while, but I find it so important to get your opinion. If we could get started, yeah. Okay, so the agenda, what you saw already in the invite, we will speak about the LLMC, limitation of liability for maritime claims, 1976, and the 1996 protocol, which has been ratified and literally becomes law as we speak. We will speak, the most important part for me, national law required. Is it good enough that we as the UAE ratified the convention, or are further steps necessary? The FTA wants to join today as well. I haven't seen them yet, but they sent their apologies and said they had a very important meeting, but they tried to cut short. They will join us as soon as possible. Then we are speaking about the Banker Convention. That is something new as well, what has been ratified and comes into law within the next month as well. And we're speaking about upcoming conventions, Technomobile Convention, close to my heart, and NHS Convention, which is on the list of the FTA. Whether it will be ratified later this year, beginning of next year, I don't know, we will see, but it is in line. If you see these conventions together, one thing comes to mind. It's the IMO has not come up with independent convention by convention. They came up with this whole liability regime. So the limitation of liability is not just a standalone. It is a standalone convention, but it's also very important in context with other conventions. Chiara, next slide. Sorry, I always have to say Chiara, next slide, and you will not see Chiara. You should put your camera off, apparently. Chiara is our marketing manager and kindly agreed to help, so she's the one holding the control here. For all of you who think, okay, I let it run, and once in a while I listen in, but I will do my emails. Perfectly, you have my sympathies, you have to do your emails. But we have a number of poll questions coming up, so try to keep one here on the discussion going here. You will not be judged for whatever comes out of the poll. Coming to the 1996 protocol, we have mainly lawyers attending today, so I will jump a little on points, but just to say, this is not something major new for the UAE. The original 1976 Liability Convention has been ratified in 1997. So that is already more than 20 years active and alive and cooking, so you should think, in the UAE. What is new now, since November 2020, we signed the protocol. I will come in a minute to explain a bit what that means. And it has been in force for a week now, just trying to do the math. So any potential claim coming up, we should be able to limit with the new levels. Now you wonder what that means. If any of you thinks either you can't hear me, or you think I'm talking total nonsense, or you have a question, try to keep the questions to the end, just if it's really urgent, raise your hand or just unmute yourself. I want to click, but I need to wait for Chiara to do the next one. So just to give you an idea, I know it's always easy to criticize a country, but just to give you an idea, the UAE is together with the top maritime nations on top. If you look at the most important maritime conventions, And then you see the little cross under. This is the amount which the UAE has already ratified. So we are on level with the main nations. I can say. If you look on the right area, you see highlighted. These are the conventions we talk about a little today. So you see, sorry, you need to like bet your head with. The LLMC convention is what we are starting off. LLMC 76 together with the protocol. That's what we are starting now. HNS Banker Convention Nairobi. Nairobi stands for wreck removal is coming next. Yeah. So coming to the convention. What is the convention? For which claims can I limit my liability? This is a very straightforward convention, I have to say. Why was it so important? You need to give an incentive to ship owners to actually continue trade. If a ship owner is facing with an unlimited liability for all of his assets and everything he's worth, there is no point in actually doing. The trade. So on that point, it would be quite important. It would be quite important to consider. We need to allow the ship owner, and most importantly, insurance companies behind the ship owners. I see Ian smiling now. To limit liability up to an amount that is reasonable for both sides. Now, again, this started, as a few of you might know, it started already with the first convention in 1957. Obviously, the amounts that were fair in 1957 are not fair by today anymore. So in 1976, the LLMC replaced the previous convention and lifted the amount. What kind of claims? Now, again, it has to be on board the ship in accordance with the operation of the ship and who can limit. That's the most important. If you look at the kind of claims, you have a claim for loss of life or personal injury. You have a property claim, including any damage to harbor works. So you have salvage or wreck removal. You have consequential loss. I mean, if we look at the recent events in the Suez Canal, consequential loss is an extremely important claim, not to be overlooked, and can go on literally forever. The claims are calculated on a special drawing rights. The European under following the United Nations, following an international monetary base, so it's easier to calculate it. So we looked at, to give you a bit of an idea, here we said for the largest vessels, we did the calculation. We would look for passenger claims. We would look at $64 million, so a considerable amount. For other claims, we would look at about 32, so literally half. $32 million limit reliability. That is extremely, I would call it extremely fair, looking the amount of claims, how high it can get. I found it interesting to look at contracting states. So far, 56 out of 174 have ratified this convention, but we're looking at about half of the world tonnage. Yeah. So now to the concept. What is it about? Again, I assume most of you know already, so I'm really quite fast on this point. It allows ship owners, including owner, charterer, manager, and operator, to limit their liability for damages which occur on board or in direct connection with the operation of the ship. I'm reading the law to you here because, again, you have any claim, you need to consider if it actually falls under the LLMC convention. In absence of the right of the ship owner to limit liability, the overall amount of damages from the loss or injury could often exceed the value of the ship and literally every asset, what I said already. So there is a reason. We need to keep international trade moving. Furthermore, it could ruin a ship owner. A ship owner will literally consider if it's worthwhile. What are the types? That I find quite important. Again, so you have a claim, it has been caused from the ship while it's on board, while it's in operation, which claim is subject to the limitation. It's very straightforward in Article 2 of the Liability Convention. First one, of course, in respect of loss of life or personal injury or loss or damage to property. So again, harbor works is included, waterways, aids to navigation. It's also including salvage operations, not to forget, and the consequential loss. The next one is under B, you see the delay. So there's again carriage, whether it's cargo, passengers, or their luggage, any delay would be covered. Then again, claims in respect of other loss arising from infringements of rights. D, and E would be wreck removal, salvage, and wreck removal. And F would be again claims involving the person taking or person liable, claims of the person other than the person liable in respect of measures. So again, any third parties who are affected, who can limit their liability. I think that we had already. So it's either the ship owner, who is also the owner, charterer, manager, and operator of a seagoing ship, or the salvor. So again, the salvor is very important when it comes to salvage or wreck removal. Next one, please. So now we have the 1996 protocol, who came into force in 2004. What is this about? The protocol is literally saying the amount, the limits from 1976 were not good enough anymore. From the experience, it's not just the inflation rate, it's the experience of claims. We all know the amount that can raise to very quickly. So the protocol mainly set the wood per ton limit is increased throughout all tonnage levels. We go through it in a bit more detail. And of course, the overall limit for passenger claims has been removed, and the liability per passenger has been increased as well. It was also tacit acceptance was introduced. That's quite interesting because it means any further increases, we do not need to ratify. Countries do not need to ratify and ratify and ratify. Any further increases will automatically apply. What is interesting for us, because there was another amendment in 2012, which came into force in 2015. So that is automatically enforced in the UAE as well, without any further ratification process necessary. Now comes, sorry, I'm just made aware that I forgot to put one poll question in, maybe to get a bit of an idea. But it seems at the moment, if I'm looking at the attendance, it seems, no, we're not just having from the UAE. Can you put the poll question up? So we have a number of polls today, just to make it a bit more interactive. Sorry, I need to move this one. Where's the first poll question? Sorry. See you. Oh, I cannot see that. That's not very good. So the first poll question, as you can see, I don't understand why it didn't come up here, is the LLMC convention applicable in your jurisdiction? Literally, what we want to know. Do you have any experience with this? Have you already worked with it to get an idea of the level we are discussing today? Do me a favor, just click yes, no, partially. What is not here, I don't know, I don't care. So just try to answer. Who sees the response? Who sees how many people have answered already? Okay, because then the question whether we close it now.
70-85%.
Okay, so we just wait a little longer, or we go for it. Okay, so this is closed now. The share, if you can see the response, just let us know what the response is. Oh, now I see this. So the majority is saying yes, that's good, and no, and partially in number. Does any of you in the audience, do you wanna say so? I'm just trying to see who else is in here. I'm closing this one. If you want to say something to the applicability in your country, maybe we leave it to a later stage when we have the discussion what it means for the UAE. So the new limits. Now we're coming to the SDR, right? It's always something not so easy to calculate at the end. So if we are raising the limits, we are looking at it move for ships not exceeding 2,000 gross tonnage. So for the smaller vessels, it moved to 3.02 million SDR from 2 million. Then you see the next level, larger ships. So again, for following larger than 2,000, so we see here, you see from 800 for first group, from 800 SDR, it moved to 1.208. From 600, it moved to 900. So you see, it's quite a balance. How it increased. Property claims, again, for smaller vessels not exceeding 2,000 GT, moved from 1 million to 1.5 million. For larger one, again, you can see from 400 to 600, 300 to 450. So it's through the level. Okay. So the forces are increasing. Just to summarize it again, if you see the 1957 convention, the amount it was in average, then the increase in the 76, the 1996, and now the 2012 amendments. That is literally in accordance with the experience of claim amounts. Now the interesting question, what we were wondering about, the UAE ratified the 1996 protocol, but it did not denounce 1976 convention. What am I talking about? I'm talking about that at the moment we have two different limitation levels here in the country. What does it mean? Is that an academic question? No, I don't think so. Because it means if I am a ship owner, I have a claim. What do? I have a potential claim against me. The first thing I would try to do is forum shopping. I would look for a jurisdiction where I have the lowest limits possible, which I could apply. So I would look for a state where I have 1976 limits, as you could see on the previous slide, where I could apply lower limits. Now I would say my smart lawyer would say to me, oh, Jasmine, I found the UAE. The UAE has applied the 1976, so we can try to file a claim there and apply lower rates. But now the UAE has the 1996 as well. So I would try to establish a limitation fund here in the UAE, saying, applying to the judge and saying, well, I would like to establish it under the 1976. Obviously, the claimant wants the higher amount, saying, no, that is not good enough for me. The UAE has ratified. I want to have the 1996 levels. What is the judge going to do? I leave this open right now. We're coming to it at a little later stage. So, but again, interestingly enough, so you think each contracting state should have denounced the 1976 to be very clear about the limits. But if you're looking at the list, there's literally just a handful of states who denounced the 1976. The majority still has both in place, or they signed only the 1996. We looked at the different states who denounced the 1976, why they have done it, and they have literally done it because they implemented the 1976 in national law. They implemented it in national law. So in order to change that, they had to denounce the one convention and agree to the second one. As the UAE has not implemented the LLMC into national law, at the moment it seems to be no need. And more we are going after. Now apparently I'm told there's another poll question coming up now. If you put the poll question up. So again, I'm asking you now, we come later to it, but we found it interesting to see your opinion. do you think it will make matters in court or predicting the outcome of a case, it will make it a little easier if the UAE would denounce the LLMC Convention 1976? Yes or no? Yes means we denounce it, so we are very clear, we have only the limits of the 1996. No means for you, it doesn't really matter. I don't know how many we have already. It's coming up. For some reason, I don't seem to see it. So apparently you can do only one thing. If you talk, you can't see the rest of the lot. But my colleague Anna is typing enough, showing my laptop screen to me so I get an idea. Yes, I fully agree with you. And obviously, any non-lawyer sitting here, just thinking about the costs, we want to have clarity. So at the moment, it looks 78% said yes, it should be denounced. 22% are saying no. So again, on that point, I agree. I think it makes it a little more clearer. Plus, what we would say a little later by today on how to implement the convention into our national law, it would be safer to go that way. So now there comes one. Now we are. Can I just say, I find this one too early. Can you just jump that slide, please? I come to that later. Should not be here. So if we are coming, no, actually, sorry, go one back. Sorry, guys, I need to get my facts straight here. So the interesting part, if you're looking at the LLMC Convention, the LLMC Convention gives a lot of leeway. I don't think I have seen any of this kind of leeway in any other IMO convention. What is just me talking about? I'm talking about that convention gives a lot of flexibility for contracting states to add on, opt out, increase liability, decrease liability, and I can vividly see the discussion around at that time and how different delegations could not come to terms and could just not agree. They could not agree what should be limited, what shouldn't be limited, whether it's possible to establish, does the fund need to be established or not, and in the end, smart people drafted the convention in a way that it's possible for countries to ratify. What's the most important is possible for countries to ratify, but still give the country the liberty to decide and to say, but this is how we want to do. What I find the most important, there is, I would say, at least 8 or 9 areas in that very, very short convention. But if you look, the most important for me was one of the most important. You have the choice to add small vessels of less than 300 tons in this convention. That means ship owners of very small tonnage, you can give them the chance to limit their liability. What I find in an area like others, with so many oil platforms out there, the smallest vessel can cause a massive problem. You have what we have constantly at certain times of the year, tug and tow, one breaks, one floats around, and oil production needs to be stopped. We have a damage of $25 million in absolutely no time for the smallest of vessels. So one area to discuss with the government would be, should we allow ship owners of small tonnage to limit liability as well? I think, so I don't know who did the poll. I'm quite sure there's a poll question coming up to it, so you have my opinion already. I think it absolutely makes sense because I have seen, as I said, I've seen in a number of cases smallest vessels causing the biggest problem. Article 6 of the protocol of the 1996 protocol. Actually, you always hear me speaking about it. So how does this thing work? Just picture, you have the 1976 convention. Now you have the protocol, you have the 1996 protocol. And then you have the 1976 convention plus the protocol. What is read as one together? This is read. So when I speak about the 1976, I literally, here I'm always speaking about the one together with the protocol. It's read as one document. So Article 6. Now again, it says for any case of claims for loss of personal injury to passengers, You can increase. If you say the limit is not good enough, we want to have higher, you can actually increase it. And what I find for me most important, if you look at the amount of claims, if you remember a few slides, okay, I was speaking about what kind of claims. And you mentioned that I twitched a little as I said salvage and wreck removal. Salvage and wreck removal, you all know, everybody who ever dealt with it, you know how cost intensive these kind of claims are. So again, and you all know how much we are working with the government here. Who picks up this bill? That is the most important for me. Who's actually paying for it? So quite often we have a single ship owner disappears, the insurance nobody has ever heard of. So all of a sudden, who picks up? It's the port of the government. Port of the government pick up the bill, and now there is even a possibility, or the insurance company says, fine, but I'm limiting my liability. Who picks up the bill? It is the owner. It is the owner at the end. So on that point, to say a government can choose to opt out of the liability, of the limitation of liability for any salvage or wreck removal. But again, I think it's up to the harbor masters to come with their opinion as well. I'm not sure if Captain Tama in. I cannot see it here. I'm sure he wishes something to say on that point. If he's in yet, let's see at a later stage. So on that point, we have a chance. That is, of course, a very important question as well. Is do you need to establish a limitation fund in order to limit your liability? So that's another point where the convention is leaving it to national law. Now I see my colleagues roaming up and down here very nervously. So apparently I'm missing. Okay. So we're having another poll. I thought the polls come later when you guys get tired, but apparently they're coming quite out here. So we're having another poll. The poll is, so again, do you think smaller vessels below 2000 GT, it should be possible for them to limit your liability if you just vote yes or no? If you can see me, because weirdly enough, I cannot see myself what is so weird because I'm not sure whatever I'm pulling on faces. If you can see me, you see I'm looking to my colleagues because I cannot see the outcome of the poll. I can, apparently. Yes, and again, you all agree, I love when I'm a part of the majority. Always good. So at the moment, it seems, are we closing the poll? Did we close it? Yes. If I see it, everybody can see the outcome now, right? Sorry, guys, as I said, I'm not that experienced in Zoom webinars. So again, the majority agrees. I find as well, I find it very important. I wish I could give you some data. There is a massive amount of smaller vessels out here in UAE waters. So I really think it would make sense to put them in the system as well. Yes, if you close that. I think we are moving on. Hold on, there was one on the HNS, but I'm speaking the HNS. So if I speak about HNS, I'm not speaking about the English healthcare system. I'm speaking about carriage of hazardous and noxious substances by sea. Everybody has seen recently social media on the Express and the fire that broke out in one of the containers. Where again, all I thought is it's about time that we modify the HNS convention here, but we speak about this a little later. If we could go to the next. So now we're coming to the interesting part. Again, anybody who thinks I'm too fast, I'm sure most of you think I'm too slow. If anybody thinks I'm too fast and you have more questions on the LLMC, do me a favor and give me a call. Not right now, I'm speaking right now. Give me a call after, because here this is focused on maritime lawyers, and most of them they know more than I do. So now the interesting part here on the interesting part on this convention now is how will it apply in the UAE. As you might know, or you might not know, I vividly remember a couple of years back pre-COVID times, I would sit in London with a club representative, and he was saying, by the way, Jasmine, I'm in the UAE. Do you apply the LLMC? And I was like, duh. I didn't really know what to say, because yes, we had ratified a convention for 20 years, by now around 20 years, but no, it's not applicable. We would have to tell any client, we cannot apply the LLMC, it's not accepted by UAE courts. It is not simply not applicable. Of course, something hard to explain because we have ratified, right? So I will tell you now how it works at the moment and what we are hoping to achieve in the next couple of months. And of course, as you saw, if a limitation can be actually established or not. So again, here, just for a reminder, for any non-lawyer, how does a convention become national law? Very straightforward. If you just look in the end, all what we need a decree. So we need a decree from the government saying this convention becomes now national law. That has happened. But in 1976, that has happened in 1997. So as I said, for more than 20 years, we should have already LLMC funds applicable, but it hasn't happened so far. At the moment, this is how it works before UAE courts. One problem we are having, we haven't got, contrary to English law, to common law, we haven't got a system of precedent. So we cannot have one case in one UAE court, and then we would all go to our clubs and say, hey, this is how it's working now. We have an established system. Unfortunately, it doesn't work like this now. At the moment, Sharia law applies quite often for death or injury. So again, we have a death on board. The police would come. You wonder what does the police do with our maritime claims? Any death or injury, police would always be called. Police would call and the prosecutor would get involved. The prosecutor is not maritime experience. Nobody expects that. The prosecutor would apply what he knows. And what he knows is Sharia law. You have to pay blood money. What is 150,000 dirham? 200,000 dirham when it comes to pounds, and moment 40,000 pounds. So it's definitely not the amount we would expect under the convention. And we have the UAE maritime law. In the UAE maritime law, you can limit, the ship owner can limit his or her liability to a much lower amount than the conventions are saying, even to a lower amount than the 1976 convention say. I'm seeing Shia grabbing the book, but you don't need to read the law out right now. Again, somebody wants to have the copy of Article 141, contact me later. I send it over to you and I give you the numbers as well. They're extremely low. Now, we had one case that actually our Supreme Court looked into applying the LLMC convention, but again, there was no clarity. Do you want to elaborate on that case, Shihab?
Yes, that's basically what
I think the speaker's there.
What happened in this case is like when the Court of First Instance rejected to apply the limitation of liability, and then the claimant has appealed. The Court of Appeal has rejected it as well, and then the claimant has appealed before the Supreme Court. Supreme Court referred it back to the Court of Appeal, where and instructed them, you should apply the limitation of liability as long as the convention is being ratified. But at the end of the day, we did not get a judgment where a final judgment where the limitation has been applied, because the case has been settled before the Court of Appeal when it came back to it the second time. So the verdict at the end of the day, yes, that we have a Supreme Court judgment saying that the UAE court should apply the convention, but at the end of the day, it didn't go through because it has been settled collectively. So that's basically one of the only, or it is not the only reference, the only reference that we have in terms of applying the LLMC.
Yeah, I think as well it comes mainly due to the fact that none of us lawyers would tell our clients to apply to open a fund, because again, being cost conscious, we would look at the outcome and we would tell the client upfront it's not it's not going to fly. It will not fly as long as we haven't got a bit more clarity or a bit more training. We had a meeting with the training institute, with the Judicial Training Institute. That is the institute that is training judges in Dubai, but is also working with the other institutes that train federal judges to say the first level we need is awareness. We need to speak. We need to speak about the convention. We need to make judges understand how that would actually work, and then they would need to apply. Because asking in a case, making the judge aware in an ongoing case, it is not easy, and the risk of your case just simply being dismissed is extremely high at the moment. That's the problem. So as interesting as it would be for us lawyers to push it through, it would be on the back of the client, because the client would pick up the legal fees for that, and I don't think that is right. So that is something that needs to be done. On the slides, I don't have the numbers of the slides. I don't know when the next. I know that I think that's the next poll coming up. Oh, I'm told not now. Okay, I think again I will get hectic science when the next poll is coming up. Now it comes to an interesting part. You have heard me before speaking about the limitation fund. What is the limitation fund? We should have had a poll asking about the limitation fund. We're speaking about the fund after that slide.
No, we have a poll.
Oh, we have a poll. Okay, but we should have a poll whether people know. So what is the limitation fund? I think fund, most of you think about money. Yes. No, now come to think about you. What we have at the moment. At the moment we have a situation. I arrest your vessel. You are saying, you know what, this is the amount I could limit my liability, so I'm putting this amount in court. You release the vessel and off we go. That is a very straightforward case. Or again, I have one claimant, here's the liability amount, off we go, and we decide the narrative of the case. But now we're looking at the Evergreen case, or we are looking at any oil pollution case. So now we are looking at, let's look at 20 claimants and more to come, but you don't know how many are still out there in the court somewhere. You, ship owner, you can limit your liability at any given incident. How many claims are there? Doesn't matter. This is the incident, this is the claim, this is the amount I'm limiting. Now it's not up to me, ship owner, to decide who gets the money. I can put the money in court, so you should think. I put the money in court, I'm saying, you know what, I looked at the 1996 level, this is the amount. I'm limiting on my club, writes an LOU. Now the club should listen up, I'm coming to that later. This is the amount, limited. You guys sort out who gets what, I'm out of it. That would be in a perfect world. Now, again, the convention is very clear to say how you, contracting state, deal with that is up to your domestic law. You're not interfering. You need to establish a fund in order to limit your liability. How you want to establish a fund, that is absolutely up to you. Yes, Ian, I see you. I was waiting for that. English courts accept club LOU. This is and now your message just disappeared. Let me come to it, because again, we come to the LOU later. And Ian, I know that was the main reason why you joined in. I got that point. If you look at it, if you look at the UK is very clear about it. It's in the CPR, it's in the procedure rules, very state. You may constitute a limitation fund by making the payment into the court. So you give the money, the fund will be established, the judge is literally the fund administrator. So there, now I see Ian's comments, because we were saying UK courts only accept cash. They have not accepted an LOU in order to constitute the fund. Ian, that is my last knowledge. If I'm wrong, I'm really happy if you say, no, you are wrong, they're accepting LOUs now, so it should be, that's absolutely right. Your chat popped out. Can you see the Atlantic conveyor? I've done it twice. Excellent. Thank you so much, Ian, because honestly, I did not research this. My old information or my information was still English courts will have a problem with that, saying there is no clarity whether an LOU would constitute fund. Thank you so much. We will actually change to which case that's like. Now again, in France, you can, again, France would accept a club LOU. Again, the application is made before the commercial court. The commercial court, then they designate the liquidator of the fund and the method. So again, the court tells you how exactly what is the next step now. Now you all know, or you can hear my accent, I'm German. In Germany, I took part in a number of fund applications. In Germany, again, you are applying, you are informing the court. The court, there's a whole law to it. Of course, nothing is easy in Germany. There's a whole law to it. It's not just a CPR, one clause, it's a whole law saying, you court, you come up, you appoint a liquidator, literally, you appoint a fund administrator, then there's a whole law how the fund administrator is actually administering the amount to the different claimants. A very, very detailed law. Russia, we saw, Russia is, again, it's quite straightforward. There is, you establish cash deposit, LOU, you establish, and the judge is deciding. And again, Singapore, very straightforward, the judge is deciding. Because for us, the question was, do I want the judge here in the UAE to be the fund administrator? Now, I do not want to say, I'm getting already the first one, I know we have a call in a second. Just to give you a bit of a background, it's always very easy to criticize judges, very easy. And people like to do it in the UAE, the judge wasn't good. And yes, I agree. In the majority of cases, I'm not happy with the quality of judgment. But if you look at the amount of work the judges have here, just if you look at the annual report of the High Court, a judge, a first instance judge, is dealing with 700 cases a year. So that's around 3 cases a working day, 3 cases a day. And now you want me to be a fund administrator on top of everything else. Thank you very much. It's not happening. So the fund administrator in a complicated case, he needs to have 100% of his time needs to be on the fund. The judge will not be able to do it. Plus, of course, which language would this fund be operated in English and Arabic? A lot of the judges, they would say, my official language is Arabic. I need to speak, I need to do this in Arabic. So do we want to have the judge? Do we want to have a maritime expert? Looking at, again, that in Dubai, we have only 2 maritime court experts. Again, I would say that would be a very tricky situation to have only one of these 2 appointed. Or do we want the judge to be able to say, I have a list of FTA approved administrators who are experienced with limitation funds. I appoint one of them. But again, one of these administrators will obviously say, I'm doing it based on what? So again, it would be quite important to then provide these administrators with a law to make very clearly what they can and what they cannot do. On this point, before I move any further, and yes, Ian, we're coming to the LOU in a bit of a later stage. But now coming to the poll, you all guess what I'm asking now. Oh, I can see the question here. What do you think, based on your experience, which authority should be appointed as the fund administrator in the UAE? Should it be the presiding judge of the case you're listening, whether it's in Dubai or Sharjah or in Fujairah? Should it be a maritime expert? Should actually stay a court maritime expert appointed by the court? They would only appoint somebody approved by the court already. Or should it be a separate entity to be established according to new resolution to be issued by the UAE authority? I think maybe judge would have said, Jasmine, this is a leading question. You cannot point the question clearly. You all agree with me, but I put you already up for that. We agree. We feel that our experience here, and all of you know me, most of you know me, I've been here for 20 years. We haven't got an experienced maritime court. We haven't got experienced maritime judges. The judges are overworked. I have to say on their behalf, they are seriously overworked. They will not have the time what I feel claimants are deserving. A claimant deserves. If we have claims, accumulated claims of 50 million for a fund that holds 5 million, the claimants deserve a proper allocation of the funds. They deserve somebody who spends time. Then again, you need to make sure something what we were wondering in the current state. I have an arrest. The fund is put up, or the money is put up in court, vessel is released. Now 2 months later, somebody else comes. These arrests happen in charge of court. Now somebody comes. I'm the ship owner here. I put my money up. For me, the thing is finished. Now somebody comes to Dubai court. Same claim. I would go to the court and say, I'm sorry, my friend, I put up the money in charge of court. It's your problem. You were too late. Nothing's happening anymore. And this will come. This will hit us here. So again, to be very clear about how the fund is published, how potential claimants can be notified, that will be something we will need to work out. But we do have 12% who said the UAE courts are absolutely able to handle that. It's somebody who voted the UAE courts or a maritime expert. Do you wanna say something? I cannot see. It's anonymous, right? I cannot see who voted. If somebody from the audience would like to come forward, I'm very happy to hear you. No. Somebody? No. Okay.
Well, Jasmine, Ian, I thought that perhaps when you've got other parties who are going to be making their claims in the fund, so that fund has sufficient legitimacy and is recognised, having it administered by a judge would probably be more acceptable or straightforward and require less explanation, even if the judges are overworked or are not sufficiently trained to be able to deal with the specifics of this type of issue. It was more about a credibility question that I thought perhaps just going through the court would be more in the line of the usual course of events.
Generally, yes. I think I agree with you. Generally, yes. Just looking at it, as I said, I took part in two limitation funds where we represented the government, claiming for break removal against the fund. We were representing the English government. It was a fund established in Germany under that law by a fund administrator. And there again, it was so detailed and so complex and so complicated, where in my opinion, a judge is literally not able to deal with that. But having said that, if it would be possible to work on a kind of hybrid, to say the judge is overseeing, so it's still the judge is the supervisor, he is overseeing, but there is somebody who can spend the time that is necessary. I can see more in dialing in. You made it. I'm very happy. Hi, Moy. On that point, I'm not sure. Either we work on a kind of a hybrid system. I think for judges it would be incredibly hard because we're dealing with maritime claims. Again, something where our courts are not experienced with. And you would need to allocate claims according to the liability. And now what I really worry about here, because we have so many different court systems here in the UAE, that you establish the fund in the Dubai court, but I will arrest your vessel in the same context. I will arrest your vessel in Sharjah court. There might be something happening in Fujairah court. So again, the moment we start playing the system, the whole thing would collapse here because it's not experienced. The system here currently is not experienced to deal with this kind of cases. One solution for me personally would be to have these kind of first cases heard in the DRC court, which is an English-speaking court with judges who are a bit more experienced with these kind of claims. But that would be a jurisdictional issue because they have the DP World Court there. They have jurisdiction only in very limited cases. But it's good to hear your opinion, Ian, because we are discussing with the FTA to prepare a white paper to say this is what is needed now, because our experience in general, is the LLMC 1976 is applicable for more than 20 years, has never worked, has never been applied. Now we ratified the 1996, and because we did not just ratify the 1996, But we ratified the Bunker Convention, and we're going to ratify a direct removal, the Nairobi Convention, and hopefully the HNS Convention. We have a whole concept of conventions. This will come to UAE courts now. Judges need to understand what is happening, and our local law needs to address the issues and needs to make sure, based on the experience of the past 20 years, this is something what courts are not dealing with at the moment. We need to provide some guidance. We had one case in Fujairah court a few years back, where again, I think one of the parties, the ship owner, he actually applied to establish a limitation fund. The judge said, I don't really understand. The judge asked the FTA for guidance, and the FTA said a fund cannot be established. What might be rightly so, because at the moment we haven't got any law providing any clarity as to how to establish the fund. So if it would be the judge, to summarize this point here, if it would be the judge needs to have something like our English CPR rules to get a clear guidance how he has to do it.
As well as, just to add one point you just, when Ian is talking about the credibility of the limitation fund in terms of claims which will come forward. At the end of the day, according to the UAE system, such security or the fund which will be added to the limitation fund, or which will be constituted, must be monitored and to be under the court supervision, because it will not be possible just to go to a private entity that I hire as the ship owner, want to my liability. Here is the money, bye bye. No, it has to be assigned by the court. This case, yes, the limitation fund will be applicable. Therefore, this authority, which has been, let's say, appointed by the law or have some expert to deal with that in their list, will be taking over from here. So therefore, the money will be within the court premises, within the court treasury, but to manage the funds and distribute it between the claimants, this will be the authority which will be assigned in a later stage. So in terms of credibility, it will always be secured once the money is deposited, because it will be deposited.
That would work.
Yeah.
That should work. But again, Ian, yes and no, I agree with you. I disagree on the point. As I said, I'm a bit worried that the judges would not be able, time-wise, would not be able to handle it. Capability-wise, once the training is provided and they understand how the system is supposed to work, yes, then it should work. Okay, if we go to the next slide. Nobody's giving any signs to me, so no policy yet. Is it possible to limit your liability before the UAE judicial system? Did you not just deal with it? Okay, you just come. So again, on that point, getting notes here again. Oh, that's the next slide. Ah, there's the next point coming up, of course. On that point here. So as we said, at the moment, I can very, very clearly say it's literally not possible to limit your liability right now under the LLMC previous. Now with the ratification, I do think the Ministry of Justice will provide a bit more attention to details here and provide, and eventually we will have training for the UAE courts as well, to say this is the law, this is how it will work, and they will not just dismiss a claim to limit. What would be, it would be good for claimants, it would be not good for ship owners, because as mentioned before, at the moment the limits are much lower. But again, overall, it would be good for the industry because it provides some clarity for everybody. So on that point, it would be a bit better. Apparently, a poll question is coming up. Sorry, I think that's the last poll question, although I personally always like it. Oh, I didn't know there's one more coming. Sorry, wrong again. Poll question number 6. Ah, that's an interesting one. Does the limitation of liability automatically, so that's a limitation literally when you provide fund, you provide money. Sorry, the question is not properly. If you put up the funds as per the limitation of liability, that amount, you put this up in court, does this automatically constitute your admission of liability? Yes or no? audience is so smart, so smart. Of course, it's the law. I think we can close it already, isn't it? Okay, we can close? Yes. I think once we close, I think then it's actually shared. Yes. Yes, of course it doesn't. Same thing, you arrest my vessel, I put up the security to have the vessel released. Does not mean I admit to any fraud. It just means I get the vessel released. I put up the money because mainly I will put up, why do I put up the money? Because you have the chance to arrest my vessel. Either you have already arrested it or you might arrest it, and I don't want to have any of that. So I put up money if I have a good club behind me, if I have PM behind me, and if eventually it works, I put up a club letter, which would be much better than parting with the cash. And then we are waiting for the main case to be decided. Coming back, that might be actually the strongest argument for Ian's point to say we have a limitation fund. The liability and quantum needs to be decided, and it should be decided by the presiding judge and not by the administrator. Yeah, there we need to see. So we might just need to have judges allocated to actually understand this. If we come to the next slide, will it be possible to establish a fund in the UAE? That's a good question. So the convention kept it very open. At the moment, the convention, because the convention is saying you may establish a limitation fund, but to limit your liability, you do not need to establish a fund. So that is up to me, I guess, as a ship owner, to say, I know very straightforward, there's one person only. In this case, there's one person only who has a claim against me. I put up the money, go do what you want with it. Or I'm saying, you never know, there's always somebody sneaking around the corner with a consequential loss claim. I establish the fund, so I'm on the safer side. There is a gap. Or the judges say, you know what, it would be better to have a fund. That is something we need to decide. I think the government needs to decide. But again, at the moment, we cannot, under the UAE, we cannot not establish a limitation fund. We cannot put up money in court, literally. So there is again, even if a judge would say, I hear you, I agree with you, put up the money and apply to establish a limitation fund, I don't think it would be possible right now because there is no guidance whatsoever. There is no guidance right now what it would mean to establish the fund. So I think subject to further guidance by the government or a clear decision by the FTA and by the Ministry of Justice how this should go, I think a limitation fund is the absolute way forward. As I said, I did it with limitation funds. I think it's the only way forward. I think just putting up the money in court will always come to disastrous cases when we have further claimants coming up at a later stage. So will it be possible to establish? Will it be? Maybe. Right now, no. My opinion. Except, as you see in this little box, there is one case in the DFC, when I mentioned before, the English-speaking court in the WT tribunal. But again, they literally applied. I promise to say they applied UAE law. They applied English law, in my opinion. Reading that judgment, they applied English law. So, and again, this tribunal. Great tribunal, but it's only applicable for very limited cases, unfortunately. So overall, right now, yeah, right now. Will it be? Maybe yes. That's what Ian was waiting for. Methods of constituting the fund before the courts. So the Constitution is saying provide an acceptable guarantee. And as many of you who deal with the courts here might know, acceptable in UAE courts is cash. You may believe it or not believe it, but that's the currency to go at the moment. So when we asked for a release of one of our vessels, or we need to provide security for an arrest, I have a nervous colleague running around because he gets 800,000, 1.8 million, he gets the money handed out by a very nervous CFO in our office. He takes it home with him because because the next morning he goes directly to Pudera Court and he isn't coming here. So again, don't get me started on our liability insurance issues when the money is somewhere in the car overnight in somebody's house. In a country that is really putting the foot down on knowing your client, AML, KYC, we don't want to have cash transactions. That the court is still only believing in cash is shocking. Any judge listening in, don't take it personally, but I find that absolutely shocking. That we cannot do a bank transfer is below me. We can provide a manager check, yes, that is possible.
Or a bank guarantee.
Or yes, but again, we don't want a bank guarantee. That's a big problem. But bank guarantee is for me as bad as a cash. At least cash is 100% out of my cash flow. A bank guarantee, I can cut a deal with my bank. Then I need to have only a certain percentage of the bank guarantee actually in my account, so the money can still work. That is okay. At the moment I cannot provide a regular check.
No. Only manager check, which is basically the money's blocked.
The courts don't trust with the amount of bounce checks they're having in this country. Again, I saw one of Ian's comment. Ian, next time you will co-host the seminar with me. Surety bond, yeah, our local insurance bond. It's not bonds. I'm not working in court here right now. I have to say, fully agree with you, and would be the best ever because we are looking at the cash flow and how much I want to have a security for my claim. I don't need your cash in my court. I need a security. A bond is absolutely secure. I fully agree with you. Courts here, I'm trying to find careful words. Courts here have not. They're doing things like they have done it 30 years ago. They have not picked up on anything else on that point. And that is really something, again, the FTA is so on our side, I have to say. But when you deal with the government, you deal with so many different ministries. And they have to find somebody who takes the decision and is saying, we are moving forward as a court. We are moving forward. The FTA has asked us years ago, we want to have meetings with the Ministry of Justice. We understand, we listen to you, we hear you, we understand. We want to convince the courts to accept LOUs, club LOUs. But then the FTA said, Jasmine, provide a paper and explain what an LOU is. Ian, you have to explain what an LOU is because it's like an elephant. You know it when we see it. You know what a club LOU is. But if you have to explain what kind of legal instrument is an LOU, that's a very different thing. Is it really 100% secure guarantee? No. There have been clubs who have defaulted on LOUs. I have to say it has happened. Little, but it has happened. Then the FTA asked how many LOUs have been issued since the beginning of time by all IG clubs. I don't think anybody has that kind of data. I don't have that data. I don't think anybody has that kind of data. How many have been defaulted? I know a number of it happened. And again, would only LOU from IG clubs be accepted, or would non-IG fixed costs, would this be acceptable as well? Could we work with any kind of bonds? If quite often, the problem on the manager's check, as you said already, you work with the insurance bond, the manager's check needs to come from a local bank. If the ship owner hasn't got a local bank here, he might be lucky and has a strong agent or a club correspondent who says, I will provide the manager's check from my side, but it takes time. It takes time to sort this out. So regular check at the moment, no. Cash or manager's check, yes. A bank guarantee at the moment with the court, they do accept it.
We had it once in one case where the amount was above 50 million.
Yeah.
And then
I think as well, it would come up, I would say as well, for a bigger amount, I think the court could be persuaded, but I wouldn't say, it wouldn't be in general, yes. I think that, yes, in a certain amount, I remember one case as well, and it was really important for the ship owner to still have cash flow going. A club guarantee, no. A letter of undertaking currently, as everybody knows, when we have any arrest situation, courts are not accepting LOUs, and they will not, no judge will hang out his or her head without the Ministry of Justice being very clear about it, that this is an acceptable instrument. Before, as a judge, nobody would want to be the first one going that way. And then again, God forbid we actually get this through and one P&I club is not following up with the obligation. That's the end of it.
Yeah.
I think then I can pack my bag as well. Leave this country, I have to say. So on that side, unfortunately, right now, not insurance bonds, no, Ian, we are way out. Good system on that point, I have to admit, unfortunately, it's way behind. What is such a shame, because if you look at how quickly UAE courts adapted to the COVID situation, every submission can be filed online. Every hearing is online, and it happened amazingly fast, isn't it? Amazingly fast.
So add a few things, like one small point just on what you're saying. I guess as well the reason behind not accepting the views, because for the courts they need to guarantee that if anything happened and the money is not collected, there is a source or a party where they can go after internally. When the clubs has no representatives in the UAE, so it will basically, how I'm going to protect the claimant's right?
I know, I agree. I think on that point, it might be, we need to consider, once one of the IG clubs has actually an office here, but again, it wouldn't be just a representative office. I don't think that would be
They exist still, but for them they are not here. They are not part of the jurisdiction of the country. So.
Yeah, or they're guaranteed by the P&I correspondent, isn't it? To say that somebody who has an office can actually assist here.
Regulated by the UAE laws, regulated under the UAE system.
Yeah.
So
at least for start, because again, it would be I think the insurance authority would have something to say as well, not just the Ministry of Justice.
It has to be.
I think that would be asked as well for their opinion on this one, and the insurance authority would come back and say we're not regulated P&I clubs.
And this is what happened, and that's what I discussed with.
Yeah, that might be. So at the moment, we are not one step further, although we're discussing this with the FTA for years. I can only repeat, the FTA fully on our side. The new draft maritime law stipulates that LOU will be accepted, but then again, whether that law will ever come into force is something I cannot. Certain times I cannot predict. I think it'd be good to the next slide. Another question. I think that we dealt with already. So the question is it mandatory to constitute limitation funds to apply the LLMC? We said already that even the convention itself says very clearly you may constitute a fund, but you can just literally you can provoke the limitation of liability if you put up the amount. Whether you want to establish a fund or not is up to you and to national law. What we have. I think it goes to the next. What are the benefits? That's quite straightforward, isn't it? Again, I mean, a ship owner will say, what are the benefits? I have to pay more now. For us, it makes it less likely. It makes it less likely to have a proper system in the country to say, you ship owner, you can limit your liability. You can limit it. Yes, you have to pay a higher amount, but honestly, fair enough. If you have caused a serious incident, so be it. And it is very important for us lawyers, as legal industry or maritime industry. It was a fantastic sign to see, because I am extremely positive that it means the Nairobi Convention and NHS Convention will be ratified as well along the line. I'm quite sure about it. So again, that means for me, the UAE is fully falling in line with the IMO liability and compensation system. And that makes it easier for us working on a global scale. It makes it easier to adopt the system and understand the system. So that would be the biggest benefit. Legal infrastructure, yes, again. So definitely it's an advantage. Another question. Look at all these questions here. As you see, this was a group event to put this together. We are all extremely busy here right now. Put these slides together, and I have to admit, I have not seen all of it. That is interesting. That I mentioned already before. I'm not sure. I did not have any case like that. Again, I'm looking for Ian. Maybe he can elaborate on it later. At the moment, what I said to you before, we are literally saying we face a bit of a problem. There is phone shopping going around. At the moment, the UAE would be interesting because you could apply the lower limit at the moment till last week, till the 1996 came into force. Now to say, if we have a claim, the convention is literally saying if both parties, so the flag state of the ship, the claimant is based here, so would be UAE law, UAE ratified both. The flag state is Malta ratified both, I think. So we have now both parties ratifying both. Both are ratified, the higher limits would apply. If the ship on one of the parties has ratified only one convention, only the 1976, and the other comes from both, I'm not really sure which one would apply. If it would be the one, what is the equal level is the lower one?
If one convention is ratified by both, which is the 1976, and the coastal states has ratified both convention and protocol, then at that time the convention 1976 will be applied, not the new limit. So the lower limit will be, and this is one of the benefits if the UAE wants to denounce, whether the UAE wants to denounce from the 1997 or not, because they still can face the possibility of applying the limits of the lower applying the lower limits for the convention.
So again, yes, to say what I would want to avoid, a serious delay in court by battling which amount is applicable, and I would want to avoid the risk of having a case dismissed because the judge is just saying, I don't want to deal with any of that, go to the next instance, just go away. So it's on that point, it would be safer, and I think it would be good to avoid phone shopping. To be very clear, we have one level, and that's about the end. The end of that. Real estate. Another question. Real estate, which only ratified 1996, be bound by the provision of the 1976. Yes, that's a bit of an academic question, isn't it? So again, you have to read these two conventions. There's a typo in it. You have to read these two conventions as one bundle, 1 and 2 together. You have the protocol that explains 1996 protocol, but then when you're looking at the law, I wouldn't really look at the protocol. I would look at the 1976 convention together with the protocol. It's one document drafted. So again, if you download, you want to read the law, please be very careful what you download there, because you can download the 1976 convention, you could download the 1996 protocol, or you could download, and that's the one you need to download, the 1976 convention with the amendment of the 1996 protocol. That's the one that is applicable now. All the others are more giving you a bit of a background. So yes, at the moment you read them, you read them together very clearly. Next. So I think maybe before we start, as you see, there is an immediate going to the Banker Convention. Are there any queries, comments? I'm looking at the slide again, but are there more slide points coming up? There is, apparently there's one more who was active. So I was like, I wonder how we had this already. I'm not sure we went to that. We didn't. Oh my God, guys, I'm so sorry. That is my mistake. Okay, this is quite an important one. Again, mainly looking at protecting the UAE government here for any unfortunate claims. Coming back, that's really my mistake. Do you believe that the UAE should opt out of the limitation of the possibility to limit your liability for salvage and like, oh my God, why am I reading it? They clicked already all of it. You guys are so much faster. I agree. Should opt out. That is actually quite interesting because the majority is saying no. So the majority is saying it's not a good thing if I cannot limit my liability for salvage or wreck removal. You wanted to limit. The problem, of course, for the government is always the government or the port. Let's say this happens in waterways. The port needs to do something about it, otherwise the waterway is blocked. The port, the government, has to pick up the slack because, of course, quite often salvage and wreck removal becomes considerably higher than the limitation amount. I've gone with the flow all of this presentation. On this one here, there is an absolute majority who says no. I kind of disagree, but then it's again because I feel sorry for the government who has to pick up the empty, who has to pick up the rest of the bill there, or the salvage companies are forced to do it for better cost. Any of the people who said no, could you elaborate? Did you say no? Sitting next to me. You said no. Any, and not any but Ian, because Ian is the only one who has said something so far. Anybody else who said no, doesn't make any sense. Maybe for Ravi to come forward. Where else is it? I can stay silent till one of you is saying something. I would like to hear a bit more because that's, for me, that is surprising. Maybe it shouldn't be surprising because you say we have a liability, a limitation system, and that has to apply independent of whatever claim we're having. Anybody want to say why you click no? 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 No, that's a shame. That I would like to, that I would really like to hear. Okay, that's not happening. So now, again, just quickly to summarize, before we come to the Bunker Convention and the other two. LLMC, we have ratified it 1996. Higher limits should apply in theory. And I think we informed the clubs. Yeah, we informed the clubs already. But we are not sure at the moment how it will look like in practice. The FTA and us, we are working on a white paper to bring it to the Ministry of Justice to say, this is what we recommend. This is what needs to happen now, to have clarity, and for us lawyers, for you industry, to be very clear about how it will apply. The government has the choice at any given time to say we wanna include smaller tonnage, where all of us disagree that should be included. That you don't need to opt for that once you sign it. You can, at any given time, the government can say, so we want to do it. All of what needs to be done, the IMO needs to be informed, and that will take months, and then it would be applicable. The government can also say at any given time, let's say the government is now saying, nope, just me, we don't agree with you, salvage and wreck removal, we will keep this limited as well, the liability. However, we have a case in the near future or in the far away future where we have a bad example, where we have the situation that we end up with a salvage or with a wreck removal, and the government ends up picking up the bill. At that point, at any given point, as I said, the government can say, okay, thank you very much. Now we see what's happening. We're not having this anymore. Obviously, the UAE is extremely looking open for trade. The UAE wants to be extremely trade friendly. So to say, we don't want to put unlimited liability on new ship owners and new clubs when you enter our ports. We don't want to put this on you. We don't want that you consider to go somewhere else because you don't feel that this is a good thing to consider. On that point, the UAE basically said we don't want to have unlimited liability, but they will monitor. I can tell you that they will monitor. So if we have a situation where the actual salvage amount exceeds the limitation by far, there will be a reaction. There should be a reaction to it. So that is only on this point what I could say. Limitation fund remains to be seen. Thank you, Ian, for your comment on this one. I didn't see it from this point, but really it might have to be judged, but it would mean judges would need to be trained on that point, and they need to find time in their extremely busy schedule already. That is the main point on the LLMC. Any further questions you are having, half of the audience is doing their emails. I guess that very well. If you have any further, either you raise it now or at the end of today, or you give me a call. You see, this is something I'm very passionate about it. I'm so happy that we signed it finally. I'm so happy that finally we have a way to speak to the Ministry of Justice and get something through. So it's a time, any of your comments, I'm excited to have the discussion. Having said that, I know you're busy, even more. Ian, I'm so sorry we put this up and we applied to Ruler's Court for this time. We had to give the time. 10:30 is good for our lawyers on a Monday morning. As we then eventually decided we open up for our friends and clients from outside. 10:30 becomes 7:30 UK time on a Monday morning. But then with the Ruler's Court, we couldn't change the time anymore. But I appreciate it, and I know you're very early. The Bunker Convention coming now. I will pass this on to Share if you want to. That's like you're passionate about this one. So we ratified the Bunker Convention, and with that I hand over to Share.
Yeah, the UAE has ratified the Bunker Convention on 10th of November, and it will come into force basically within less than a month. The Bunker Convention, basically, which is gonna be good for protecting, like preventing oil spill. Yeah.
Oh, thank you. That's okay.
And to protect the right of the ship owners and the persons of providing the insurance, which is insurance company, and other security to limit the liability according to the limitation of liability, which we have been talking about anyway. And as we all know, like the Bunker Convention is not as much debatable and doesn't have a lot of information to be provided, just a very straightforward convention, which is basically preventing oil spill and protection to that, and the limitation of liability in accordance to that with the convention and the protocol. Next slide. Well, as you can see, the Bunker Convention has been entered into force in the 21st of November 2028, and the contracting states so far are 100, which is a lot. And based on that, is like which is covers 95.6% of the world tonnage, which is, we can see how important it is, and the reason of ratifying such convention, and that's why we believe the UAE has entered into that, and accordingly they ratified as well the protocol. So basically, like we'll talk about the board of definition of the owner, including registered owners, barboat charters, managers, and operators. So these people basically will benefit, or will be benefiting, yes, from the convention. And at the end of the day, like it's strict liability and very limited exceptions from the liability, and compulsory insurance for a ship over 1,000 tonnage, and the limits of liability, and a direct action. So pollution and damagements. Here, what are the conventions? Why the convention is being done? Basically, we have to define the pollution and the damage. The pollution, which is loss of damage caused outside the ship by contamination, and then the cost of preventing the measure and further loss or damage caused by the preventive measures. So basically, when an oil spill happens, and which caused some pollution, and at the end of the day, this is the damage, and the recovery and to fix that damage will be considered as part of it as well. And here, where can the limitation of liability be limited? here we're going to talk what are the benefits of ratifying the convention. So to fulfill with, like, for the point of view of the maritime administration and from the point of view of a ship, for the ship owners to encourage to develop the continue operation, which, and then the ability to limit their liability, and then as well the sustainability of the vessels, which gives more credibility on the areas or the ports or the states that they are going to hold with their vessels. So they know they are a bit protected as well. From a point of view of the administration, to fulfill with the international maritime requirements standard, which what the UAE is trying to do here, enhance in a confidence in the UAE maritime sector, which provides the security for all the maritime industry, with ship owners, charterers, P&I clubs, whomever part of the maritime industry will have more security that the UAE is a good place to trade, a good port to go. And finish of legal framework for the compensation to protect the coastal tourism assets and facilities. So this is basically, which is protection for the environment, protection of the coastal ports. UAE here, as we all know, it's very famous as a tourism country. So their coastals, their fancy hotels, 7 stars, 5 stars, whatever, they need to be protected somehow, because this is a very big part of the national income of the UAE. So by having such, by ratifying this convention and having the UAE regime, you are basically trying to prevent any environmental pollution and to protect it for the use of the country. Okay. What is the effects? What effect the ratification to the Bangkok Convention will have? Now, so we will talk about the no separate limitation fund, unlike the CLC, subject to the limitation law applicable in the jurisdiction where the claim grows, and then the insurance companies can limit, and the PNI can limit their liability or the amount calculated by the LLMC and the protocol as well. It depends whether the country is part in which convention. And here, if we can talk about that. So we have already discussed limitation of liability. So if any claim or damage where the ship owner or a charter or an agent can limit their liability. Here, once the UAE ratifies that, in any oil spill, any oil pollution will happen, like it comes out of an oil spill, you will have the right to limit your liability according to the 1996 or the 1976 convention, because since the UAE is part of both conventions, so both might be applicable. And here we talk about the Wakashu case. Like, we all know that this was a big incident which has happened, and we, as far as we know, that this was a clear indication why to ratify the 1996 protocol, because the Wakashu case, if the 1997 convention will apply, the limits of liability will be too low to the claims and the damage which has been caused because of such incidents. Therefore, the ratification of the 1996 was very important to come in place because of the limits that they provide, especially after the amendments in the 2012. So the limits become higher, recovery become easier and more doable, and less cost for any country or a coastal state to spend from their own pocket to try to prevent the damage. Kiara? How do the UAE courts currently decide on the oil spill matters? So before ratifying the Bangkok Convention, there were basically the common UAE laws, which is the domestic laws here, which is law number 24 of the year 1999, which is basically was a very poor law to determine on pollution or environmental damage. And according to that, there was no much protection for the country or for ship owners, or a clear guideline how this should be applied, how this should be compensated if an incident like that happened. And it did happen, and it was a big mess at a certain point when it comes to litigation and claims and the involvement of the damage for ports, for hotels, for fishermen. So it was not really clear. Therefore, by ratifying that bunker convention, we see that there will be more guidelines, there will be more protection, because the UAE is already, as we said before, has ratified the limitation of liability and now the bunker convention. So this environmental law will not be applicable like at the moment once it comes into force, and then we'll have more guidelines. However, the oil, when it comes to oil pollution, the UAE court will refer to the International Convention on Civil Liability for Oil Pollution and Damage. This is what as well has been applied before, because this has been ratified in the UAE in addition to environmental. So both of these will happen. But this oil pollution, it has a separate type of claims where it falls under that. So however, will not fall under the bunker convention, will go as an oil pollution, and then this convention will apply. Now we come to Nairobi.
Before you come there already, is not just to state on the bunker convention. I think that the most important is one is you as a potential claimant, you have a direct claim against the insurance company, and then mandatory insurance. So for me, mandatory insurance is the most important. Any ship, what she has said already, any ship about 1,000 GT, that is mandatory insurance, and the government is very clearly here. You need to provide. Next to the CLC for oil spill, you need to provide a bunker CLC certificate as well. That will be mandatory. That will be mandatory in a couple of weeks. The certificate needs to be provided either by your plug state, and again, there is a bit of a query if the insurance company is non-IG, if it's acceptable or not. So on that point, the FTA will come out with, they will clarify the expectations. But the bunker certificate, that needs to be on board the ship. That is quite important. If the ship will not have, and the FTA is very clear about it, moment it's mandatory, the bunker certificate is not on board the ship will be stopped. The ship will be stopped at any point from port state control. So there again, that needs to be kept in mind. We will update the clubs on the requirements, because as soon as the FTA comes out with more guidelines, but I think we got that already.
We got that already, and
we got that. We will send it
so
out.
the blue card will not be sufficient enough. So
yeah,
basically the CLC and the bunker certificate and the blue card must be on board with the vessel before calling to any UAE.
Exactly. So that is, and then again, as we said, the mandatory insurance, that is good news. It is a strict liability, but then at least something. Good morning, Mohammed. I just see everybody here. You see in the chat, Mohammed Al-Kabi. I think I should say His Excellency Mohammed Al-Kabi. He's the permanent representative of the UAE to the IMO. I'm very happy that he managed to attend today, because I know Mohammed, I know how busy you are. I really appreciate this. So I'm just trying to find, because it popped up and then it disappeared again. Mohammed, do you wish to say something? I think adopted conference resolution.
Yes, hi Jasmine, and good day to everyone. Sorry to interrupt your flow of the comprehensive discussion about the civil and liability compensation regimes, and I thank you for the invitation. I just would like to very quickly highlight one of an important resolution. A conference resolution was adopted by the IMO, and I pasted that in the chat function, if you can see that, because that is also very important in relation to both the Bunkers Convention and 2001, and also the LLMC 76 and also 96, Protocol of 96. Because in that resolution, the IMO, after the adoption of the Bunkers 2001, issued this conference resolution, which urges all states that have not yet done so to ratify or accede the Protocol of 96 to amend the Convention of the Limitation of Liability of Maritime Claim 97. And therefore, they also encourages state parties to the LLMC 76 to denounce the convention with effect from the entry into force of the Protocol 96. And this is what actually the UAE Maritime Administration is doing after the ratification of Protocol 96. Now they are taking the process to denounce the 76. That might take some time. The reason behind that, because we do not want to have two different regimes, as you may explain in your brief, that whether we might have a conflict between whether the claimant or would decide which regime is applicable to them, and therefore we have suggested internally to denounce the 76 and continue with the Protocol 96 and its amendments. As you mentioned, in 2012 there's an amendment, and also in the this was one of the reasons. The second reason, as I just mentioned, there is a conference resolution to encourage member states to denounce the 76 as they accede or ratify the 96 LLMC. So this is just a highlight. In addition to that, there is also unclarity about the mechanism in order to increase the limitation. And there is also a document which is going to be discussed during the forthcoming legal committee on this matter, because as I mentioned, any increase would definitely need to have some kind of experience based on the incident, and there is no sufficient data so that would allow the legal committee to decide on the increase of the limitation. So the discussion is still going on, and we will keep you updated on this matter. Thank you so much, Jasmine.
I appreciate that. Mohammed, while we have you there, we just have, I think you died. I know you were very busy. More told us before. You died in a little later. We had a number of calls. I'm sharing the link with you. It was quite interesting, exactly on these questions. Now we dealt with the LLMC, with the Bunker Convention. We just wanted to say something on the Nairobi Convention, on the HNS Convention. We don't want to go in detail there now because one is we are nearly done with the time. The other one is we haven't ratified. But Mohammed, is it possible for you to tell us a little bit if I know the FTA wants to ratify the Nairobi Convention, but where do we stand? Is this something we can expect to hear from fairly soon, or do you say this will take some time?
Yes, Jasmine. The Nairobi Convention is also one of those conventions which is the Maritime Administration is working on, and I don't know how long will it take, but still there is a discussion with the legal department in the Maritime Administration, and also the technical part, because again, this is one of the important one. But the issue of the Nairobi Convention, whether we have to, extend the applicability into the territorial sea, because that's also something which we have to consider. But as I'm telling you, this is one of the convention that we are working on. The other part, which is HNS Convention, I think this is still not being, the process still not being initiated yet, most probably in the next year, also considering the HNS 2010 protocol on that matter, because we had also an extensive discussion with both the IMO and also the IOPC fund. Because why IOPC funds? I think the reason behind that, the fund is going to be the one who's administer the protocol 2010 NHS. So the assembly of IOPC fund will be also be responsible for the HNS 2010 protocol. that's going to be in the future. So far, the protocol is being, I think, ratified by 5 member states, if I'm not mistaken. But still, UAE has not initiated, the Maritime Administration of UAE has not initiated the process towards the accession of HNS Convention or ratifying the protocol of 2010, which I believe it is the missing piece here, along with the Nairobi Convention when it comes to the civil and liability compensation regimes. I hope that is helpful.
I thought about, yeah, of course, Mama, thank you so much. No, I thought about it recently. Remember, a couple of days ago, social media was full about the Express, the absolutely new container vessel was burned down. There was fire broke out in one container, and the whole vessel burned down. And again, I thought about the HNS Convention, thinking if this happens in our waters, we need to consider maybe at the moment the administration doesn't understand if it affects us, how badly it will affect us. We had a number of vessels mainly on container ships. There's again, it comes to these kind of substances what would come out. So I do hope that we consider it. It does make sense to have the whole regime ratified. On that point, the rest of the audience, we are the Bretton-Woods Convention is very close to my heart. So again, there's something what Mohammed mentioned very shortly. There's a discussion. The Bretton-Woods Convention is literally applying to the territorial sea, but you can opt in to go to the whole exclusive economic zone. So to extend it much further, well, obviously, I think it makes sense. The wreck removal is quite an interesting concept because it literally says, you ship owner of the sunken vessel, whether you're liable or not, I can't care less, you pay for it. You remove it, you pay for it, everything else will be sorted out later. Where at the moment, we have a problem because at the moment when we have a sunken vessel, the ship owner would say, but I'm not liable. I'm not liable. And another vessel vessel A, who run me into the ground cost it, so they have to pay for it. Then you have a case 3, 4, 5, or maybe 10 years in court, why we have a danger to our national navigation because the wreck stacks there needs to be removed. And again, governmental ports have to pick up. So on the wreck removal convention, I find it very important to say, independent of liability, you insurance company of that vessel that's sunk, you are liable. We will not have any discussion on it. That is definitely something we need to consider. So I'm happy to hear that it's in the pipeline. I think as soon as we know a bit more to the date of ratification, we will inform the industry as well. Said on that point, I think we are nearly to the end of it. I know everybody needs to go back to their desk. Are there any queries? Any comments? As you know, what I said in the beginning, this was a bit of a trial, having a half active discussion and half people from outside. I do hope that our next event we will be able. There's somebody raising their hand. Yes, I see Alistair. I don't see it. I don't know. I need to get used to the system. Alistair, I see you raised your hand.
Yes, I just had one comment from a personal experience quite a long time ago now. It was back in 2008. There was a vessel called the APL Sydney that was anchoring in Port Phillip Bay in Melbourne. It was a very windy day, up to 40 knots. Basically what happened through a series of mistakes and negligence on behalf of the pilot. He was only on board the vessel, I think he left 4 minutes after they dropped the anchor or something, and vessels were moving all over the place. But anyway, the ship dropped the anchor at the direction of the pilot. It started dragging. The captain asked if he could raise the anchor, was told no. Asked again if he could raise the anchor sometime later and was told yes, and started to do so. In doing so, he snagged an undersea gas pipeline. And that, it was a huge deal. It basically supplied it supplied half of Melbourne in terms of gas. And anyway, so he'd snagged this pipeline, but hadn't ruptured it. They then decided, because the windlass had broken at this stage, they then decided to drive forward and try and get off the pipeline. And in doing so, they ruptured it. Now, what the court held in this instance was that, yes, the limitation of liability applied. I mean, the damage was in the billions, but the limitation of liability applied, so it came down to, I can't remember, 76 odd million or whatever it is. But the court decided that there were two incidences that occurred there, so it doubled the liability. The first incident was snagging it, the second incident was driving forward and rupturing it. So even though you might think that one set of circumstances you're limited, you need to be a bit careful about what actually happens during that circumstance. Otherwise, the courts might find that you've done multiple things wrong and attribute multiple limits of liability. So it's just an observation.
No, Alistair, I appreciate, because again, we went over the point for which claims. We went over that fairly quickly, where again, you have a long-standing experience here in this country with the courts. So now again, one is I have a very clear court's grid, very clear, very straightforward. But there's so many incidents I have in mind where I thought it can be disputed if the convention applies. And exactly if you say something like that, then just say, will it be one, will it be two or three? And again, if the administrator will be a judge who's not a maritime judge, who's not experienced, who has to rely, and we are not allowed to provide party witness or party experts. So again, it would be the court expert trying to provide his opinion. It will be a tricky situation. But then again, it sounds a bit, I don't know, it sounds a bit, in your case, it sounds a bit that the judge tried to enlarge the limit a little by creating two, because for me that sounds like, well, I'm sorry, that sounds like what.
Well, I think he did. Essentially, it was the pilot who was 100% negligent in this instance, but because of pilot's immunity, his total liability was limited to $5,000.
Yeah.
And I think the judge was sort of looking to help out the other claimants who'd lost. I think it was north of $1 billion, but certainly in the hundreds of millions.
Yeah, no, it sounds like it, because for me that sounds like one accident. Plus, because even when you look at the LLMC speaks about the incident and consequential, so your damage and consequential loss. So again, that would be whatever consequential loss comes to it, it's still within the one. So we need to see what judges made out of it here when we once we are actually able to apply the limitation. We need to see it on that point. But sorry? Oh, Mohammed, please.
Oh, sorry. Thank you. It's just to respond to the maybe query about the I think the APL Sydney incident. Is clearly indicated. It's actually is one incident involved in that situation. So my belief is only one fund could just be established on maybe two separate claims. But my understanding, it's not two separate incidents. It's just one incident to deal with two different claims. So this is just to.
No, that's the conventional wisdom and what everybody sort of thought was appropriate. But the court actually found that no, it was in fact two separate incidents.
Yeah, we always, we always respect any judgment, comes from the court. We cannot, I would say contest or challenge any judgment. So we do respect that kind of judgment, and I think we have to comply maybe with the court's proceeding with that. Thank you.
No, I think that's right. We will get this kind of experience here once we start applying the system.
Well, we are lawyers. We don't accept it. We always appeal it. So.
There's something more, isn't it? How much? Yes, here definitely. If there's any further queries, I cannot see any hand rising. Otherwise, I'm just saying, if you come up with any further comment, or you think later today, oh, by the way, what about this? You know, if you don't know me, you know any of my colleagues, you know any of us. So pick up the phone, give us a call. As we are saying, we really appreciate what the FTA is doing. We are helping, we're having the white paper. So the more comments, and don't be nice to me, huh? The more critical you are, and the more you say, but just a minute, we consider this. That is extremely helpful for us because we want to provide a proper paper, because again, the FTA has a big job at the end to convince the Ministry of Justice that further steps are required. So any help would be appreciated. I see Chiara saying, oh, so Chiara, you see this funny question mark here in front of you. So the dot, you're so advanced, Chiara. The dot on this question mark is actually a QR code. It's actually my QR code. It leads to my business card. So if you haven't got my contact details, put your phone on this QR code, click on it, then you have my contact, and then you just click on a plus, and it's saved to your contacts, or you can contact me directly. That's next generation here. I'm very impressed. Having said that, thank you so much for your time. Ian, I'm so sorry that we started so early. The next one will not be as early. I do hope the next one will be in person in some big ballroom with a lot of social distance, but I'm missing seeing all of you a lot. So that should be the final words. Thank you so much. Wishing you all a good day, a good week, and keep the comments coming. I think with that one we can leave. Oh, sorry, Chiara, for CLPD, do the people who join, how do they register, or we register for them?
Register for them, and they have a code in the invitation. So
excellent. So any of the lawyers who need CLPD points, if you haven't managed or you have any problem, contact us as well. We help you with points for good support. Okay. Thank you very much. Thank you so much, Ian, Mohammed, Alistair, for your comments. Have a good week.